Please have a seat.
I'll be conventional.
Just before we get started, just in case.
Nice to see you again, Judge.
I'm gonna move this.
Thank you.
Just obscure the microphone,
Okay.
looking this way.
As I said, it's nice to be seen, better to see all of you. Thank you.
Good morning. We've met several times. My name is Michael Sasso. I have the privilege of being the chair. And the way we're going to proceed this morning is each of the commissioners will introduce themselves. We have one commissioner, Commissioner Amanda Perry Carl, that's on the speakerphone. After we do those introductions, you'll have 2, 3, 4 minutes, whatever you need to make an opening statement. Then we'll have about 20 minutes of Q&A, and then I'm the guy that gets to interrupt you at some point in time, call time, and then you'll have an additional 2 or 3 minutes to make a closing statement.
Okay, thank you.
Good.
Good morning, Your Honor. Vincent Citro from the law offices of Horowitz and Citro.
Good morning, Craig Dyer, Public Defender's Office, 7th Circuit.
Andy Bardos with Gray Robinson.
Michael Sasso and Sasso and Sasso, and she's got it on mute, so I'll introduce Commissioner Amanda Perry Carl.
Good morning, Your Honor. Brett West with Schatz and Bowen in Orlando.
Good morning, Your Honor. Petra Brownlee with the Brownlee Law Firm.
David DeArmas from Kramer Price and DeArmas.
Your Honor, Scott Thomas with Byrne Foreman.
Well, you know, it's no secret, I am Michael Takac. I've been a circuit judge since '06 is when I was elected, so I took the bench in January of '07. You want to know why I wanted to be a district court appeal judge? That's because I just want to be part of writing easy to understand opinions, concise, and not explain the law. Well, not explain it, but apply it to the facts in that case. Hopefully they don't need an explanation, but where necessary to make it easy to follow. That's my goal. Timing, last time I was here, I was asked a timing question, and frankly, there's no better timing for me to take on a new role, do the little extra homework I think everybody's tempted to do when you start a new assignment, because my nephew and our youngest child with my wife is about to leave so that they can start college with the other 2 nephews I have already gone and the oldest. So it'd be a nice transition. I was wondering the other day when, I told my wife, I said, at their worst moment, we'll miss them next year. And so it's a nice time to make that transition. But it is the attraction to the law writing. I enjoy it. I'd like to do it. I'd like to be able to do more of it. A little bit of a circuit judge is a little bit fact intensive, maybe not so busy on explanation as it is to make sure you get the facts down so the appellate court has that if necessary. And so I think that change is something attractive. The other thing that I do enjoy is the back and forth of being able to probe somebody on why their position is what it is that comes in the appellate bench. If you're lucky, some people like me for that. They will refer to it as a hot bench when you get some questions for the judge. That can be a little bit unnerving in circuit courts. I try to take that down a little bit. I want to talk to the people. But other than that, anything that you'd like to know that would help convince you that I am one of the people that should be considered by the governor, I appreciate the opportunity to answer that.
Thank you, Your Honor. And Brett Rent and I had the pleasure of speaking to your references and really doing a little bit of a deeper dive with the rest of the panel on you in particular. They had some fantastic things to say about you, your character, your personality, and had some great stories from just showing that you, in doing your job, will stand up and do the job in the face of, in their words, insurmountable political pressure, that you would put aside and do what you needed to do and follow the law. So wanted to share that with you. You mentioned family, and I understand that you just got, I think, married. Congratulations. I think it was this year.
I did half a century on my own. It was time that I...
There you go. And so I understand that you're caring for your nephew and your 3 children, but in here it was a little unclear about what their ages are.
It is.
I don't want to get too much into them.
Listen, I apologize for that. I try to protect them.
Sure.
When you're a judge, you're going to meet people, you'll offend some, not some. I think they're entitled to their lives, so I'm a little bit protective. Quite frankly, I don't like running around telling people I'm a judge for the same reason. You get a little bit different look or treatment, the respect that you get shown. So I try to let them be ordinary. I've essentially been with my wife for about 10 years, as she will tell me. And we were officially married with a not lost license and for other reasons in January, but I've been with her for a while. She has 3 children. The youngest is now a senior at Mount Dora Christian Academy.
Okay.
With my nephew, the youngest of my sister, who came with me last year. I was lucky that he's got a great mom and dad. He came down because he wants to go to a service academy. If only one of us can get a nomination this year, I hope it's him. He wants to apply to go to a service academy. Mount Dora Christian Academy had a STEM education, and his mom and he evaluated it and decided that if I show the academies what I've done in that type of curriculum, maybe that'll help. So we took him in last year. I was his guardian. His brother was a senior in high school. That's why mom and dad didn't come down. He's now in college. He's playing lacrosse. My oldest nephew is playing baseball in college. So they're lucky. They got something to give them a little extra to study help. And anyway, that's the situation. So I had four nephews. Three are in college.
Sure.
Kevin's a senior in high school. He'll be the last one out of our house. We have a daughter who's working now. She's working on being a vet tech and employed there. And the oldest is finding his way through one of the state universities here.
And I appreciate it. I just wanted to see if any of them were lawyers or if they were
No
another
lawyers.
shade, any conflict. That was the only reason for the
No.
question. I did not mean to
They're
pry.
all very important to me. If there were a case that involved them, it'd be tough for me to handle it. I'd have to
Right, you'd have to
decide.
recuse yourself.
Knock wood, hopefully, if they go to court, they don't need an appeal.
What, in this application, you mentioned the Greater Ocala Community Development Corporation. What is that?
When I was still practicing in Ocala, it was an organization that was set up to help minority business owners get going and developing. And I'm not even sure it still exists. I don't know how
Right.
well they did after I left. I know they had the person misuse a credit card and they had to deal with that. I don't know that the organization still exists. I know while I was there, it was instrumental in getting some affordable housing units where they went into a partnership with that company, and it was worthwhile, and that's essentially what it was. With the community outreach, it was a little bit flattering. I'll be candid with you. When my family moved to Florida, I knew some of the children of some of the people that were involved on that, asked me to come on the board, and it was nice that they thought enough of me and thought think I could be able to help, and that's what I tried to do.
In question number 34 in the application, you mentioned that you may have to recuse yourself as you had reported somebody to the Florida Bar for unethical conduct. Can you talk through that a little bit about what led you
Sure.
to the decision to have to report them?
I had in that particular case, I had an attorney. I don't know that he regularly practiced in Florida because he advertised his office was out of state. He came into a case, it was started out as a family law case. The family law case had gone through every judge in the circuit before I got on the circuit. It had gone through many attorneys. The divorce litigation was longer than the marriage. So the two parties did everything they could to instigate the other. This particular counsel who came in then made some representations that were just factually incorrect, and you could say them on the record. As a matter of fact, I think he talked about it. I went out and found an examining committee, and the petitioner, who was his client, had on the side filed a request that she lacked capacity to participate in her case. And so she wanted a guardianship. And it was her counsel at the time who said, here's the examining committee members. And so when he wrote that, with the course of some conduct in the proceedings, I said, you can't do that. You have to be candid. I had some trouble with that, so I just wrote the opinion and an order that said, I don't know that they had any grounds for recusal. I can't remember if they filed a recusal motion, but I think what happened was, in response to that order, I said, well, what it was is the relief has to be denied, but counsel did this. That seems to me to be unethical. Because I'm reporting it, I'm going to bring it to the next judge. So that's what that was. I did write an opinion. I said, look, I'm going to forward this. I had talked about, let's be candid, what I thought the ethical obligations were. I couldn't get them to comply with my request, so I sent it on to the bar, and I think they handled it by.
So you gave a couple of general prods and he wasn't listening.
Right.
Yeah, I mean,
Just don't take it for that.
I tried, it was, you know, on the face of what was in writing, I thought the best way is, okay, I'll send it out in writing and let them deal with it.
So let me ask you, kind of changing off the
And
application.
he had come in, and then I think the recusal that you speak of is after that, another case came in, or he had another case, and I said, okay, I wrote that letter, I'll let you,
Right.
I'll recuse that. And I think the rule requires that, that's why I did it.
Sure. How would you describe your judicial philosophy?
I apologize to the litigants, because without being presumptuous, I tell them, look, I run it a little bit like an appellate court, meaning I want things to be right in front of me. If I have to decide facts, you know, I don't want to speculate or get a lot of weight. Judge, what do you want me to do? I want you to try your case. You know, don't ask me for advice, don't ask my JA for advice. So I try to rule on the dispute that has to be ruled on. I just think cases go efficient that way. If you start trying to speculate, you're going to cause problems. So that's my philosophy. I like to tell the attorneys what I'm thinking, what's on my mind. If I understand that point, I say, I think I understand your point, because this is how I would categorize it. And if I'm fine, they can move on to the next point that they want me to understand. So I'll ask them questions. And for regular appearances in front of me, like for instance, now I have a lot of Department of Children and Families cases, I tell them all the time, don't shrink away. If I ask you a question, that doesn't mean abandon ship. You know, the judge doesn't like point, because I do the same to the other side. And I'm fortunate, I think people that repeat in front of me are used to it. Sometimes, you have to bend over backwards. I just say, look, I'm the finder of fact, I have to apply the law. If I have these questions, I tell them where it came from. When I was in law school and I took the appellate advocacy class, they said, answer the judge's question. If you want to know how to prevail in an appeal, answer the judge's question. So I tell the attorneys, I just try to tell you what my questions are. And then if you can answer it, in fact, that's when I had the best success arguing as an appellate attorney. I tried to sense what the question was. I read the ones I didn't answer and happy to grab the ones I did.
And just one more question, I don't want to dominate all the time, I could talk with you all day about a number of other items, but is there ever a situation that could be before you that you would go outside the pleadings if you think it's really the right thing to do? Maybe the judge, you know, lawyers are missing.
No, I don't think you can, because you can't set limits and boundaries on that. I mean, once I go outside, you know, the cause may be just, but if you haven't pled it, if you haven't framed it, if you haven't given the other person the due process notice, I mean, then where does it stop? And that's just, I don't think the public, I don't think the lawyers, you know, I don't think the Constitution contemplates that that's a fair way to handle it. Because then, yeah, okay, it's great if we all have Socrates or Plato as one of our judges, but, you know, you're setting a precedent for the person behind you. And so no, short answer no.
Thank you very much.
Judge, good morning. I noticed on your application that you spent about 3.5 years working in Tallahassee, first for Attorney General Butterworth and then for Governor Childs. Can you talk about that experience, how you...
Yeah, actually, my time in Tallahassee was a little bit longer. I worked, it was about 2.5, I think, for Butterworth. That position got me a promotion. I was doing a pretty good job, so the attorneys kicked me out of Polk County to work for the governor for a while. That's one of the gentlemen who hired me later said that. So I was a trial attorney assigned to the Attorney General's office. I was doing primarily end-of-domain litigation. That's why I spent so much time in Bartow, Florida. I then got a chance to work for the governor's office. It was a nice opportunity. I called my uncle the first day and said, who'd have thought it was a tax working for the governor in state Florida. You know, that's for, I mean, I was the first one born here, so it was kind of neat. I learned a lot in how to talk to people. You learn a little bit more about patience. It wasn't the litigation that I enjoyed. You know, I knew sometime in law school that I'd like to try to be a judge. I'm grateful that I was able to succeed in that. Governor's office was a little bit fielding, called, answering questions. The most important thing, the reason I was told they hired me is that tobacco litigation was going on at the time. And J. Hardin Peterson said, I don't have any litigators. He goes, my client has only had 2 attorneys in her life. One was me, the other was the governor. She appreciated the way you treated her at mediation. I don't remember the woman, I can't remember how I handled it. But it was a compliment. I took it at face value, so sure, I took the job. And I think they'd asked me some advice on what I would tell the attorneys on tobacco litigation once the governor announced the settlement. And they didn't take my advice, but it was okay. There was a big dispute over the fees at the time. And I said, well, the contract says, you know, you're going to do the mediation. mediation first, tell them, sit quiet till they go to mediation. Governors have to handle things different than court of law. So that's what they did. So there was some work as the litigation got to the extent it came up. I think we had to do a firecracker. We had a drought one summer. I think I had to tell everybody, yes, we can, you know, we can ban fireworks for a while. This is the way it works. So we did that. The tobacco contract, Tallahassee, before that was litigation of eminent domain. And then I went back into private practice, and then they had changed the vesting for retirement benefits, and I was in a little bit of I had run for judge one time, and I thought I might run again, and so I applied again and went back and I worked for Attorney General Chris for a while as well. So I had 2 stints with the Attorney General, and did eminent domain again, and during that posture I was able to run for office and go back.
Can you talk a little bit about how your position with the Attorney General's office or the Governor's office might have shaped your views on the law or the separation of powers, if it did?
Well, it made me keenly aware of the separation of powers, but I think when I try to explain in there, and I try to, in my references, give a cross-section from Ronald Meyer, was somebody who supervised me when I first went to the Attorney General. That was a long time ago. I think some of the newer attorneys in front of me now, I think I've been pretty consistent in my practice. But I think what I've had is the perspective of different places. I've been a government lawyer where you operate on a fixed income. I've done that with the Attorney General. I've done that with the Governor's office to the extent I'm doing that now. I've been in private practice where, you know, maybe you get bonuses, maybe. I ran my own law firm when I was practicing by myself. I've been in a small association when I was up counsel with somebody. I've been in a bigger firm. You're with the Attorney General, you're in a huge firm, you have a lot of resources. So cases have some practical remedies on lawyers. You know, a solo practitioner, the brief is maybe a little bit more of a burden on him than a big firm with a appellate division. So I know there's those practical differences, and I think that's really more what I apply. Keep in mind when somebody needs a break, trying to give advice to counsel. You know, sometimes telling an attorney, you can get in a match with that big law firm if you want a paper war with them, but they're going to inundate you. You know, never underestimate the value of picking up the phone and making a call and being true to your word.
Great, thank you.
I don't know
That's
if
good
it's shaped
advice.
law,
That's good advice.
Judge, I'm wondering, can you tell us a little bit about your approach to stare decisis? So imagine, if you will, that you got the appointment and you're sitting on the 5th District Court of Appeal, and the 5th District is sitting on bunk to determine whether a prior precedent would be overruled. And there's a lot of talk about the fact that it should be among the judges. Everyone seems to be going that way. Can you talk a little bit about how you believe you would approach stare decisis?
Well, if you give me no factors, no law to talk about, I think stare decisis is the principle that we have to apply. So if there's a particular case, and you have a case coming up that you don't want controlled by the stare decisis case that you have or cases, then I think your first obligation is, if you think it's wrong, then you need to explore why, where you can differentiate it from the stare decisis. I think it's dangerous to just say, okay, that case is no good, we're going to get rid of it now. I don't come to the appellate court requesting your approval because there's a decision out there that I know of that I think needs to be overturned. Having said that, I also went to law school and realized that, you know, the Supreme Court of the United States has changed its opinions as things have gone by. You know, it used to have separate but equal. It has gotten rid of that. So, and I'm not sure that I come here with a qualified example to show you when it would be time to reject that or not. I think if the question is just stare decisis, I don't think it should be willy-nilly be ignored. I think it should be given great deference. See if it's distinguishable. If not, then see, okay, what are the facts? Why is it a different case now to be the leading precedent? I think sometimes when a case has to be overturned, maybe it's more misunderstood in the public or people reporting on it than it really is wrong sometimes. I had the good fortune of doing an access case where they said access is gone in eminent domain. You can't get access law anymore. And I said, no, I think you can. And I was able to get a decision on DOT versus Kreider that I mentioned as a case, because I think it was more just explaining, no, this is the law we always had, this is how it applies. There may be, you know, properties across the street that look different, but they are different in here as well.
So you, are you the kind of person that thinks it's more helpful to give guidance to the litigants that come before you?
I think if you're clear in what you write, then, and then they understand what the reason is for your opinion, then yes, to the extent that's guidance, and that's what, you know, I would be endeavoring to help fashion those type of opinions. That's what we have the appellate court, so people can read facts, see if they're similar to their application, and say this is how the law applies to your case.
So how do you feel then about the PCA? I mean, do you think that that's a good idea, or it is not providing litigants with sufficient guidance?
Well, my understanding of PCA, if somebody takes an appeal because they want to take an appeal and it's been decided 9, 10, 15 times ahead and there's just not anything, then, you know, I can understand. It's like your case has no value. It's no different than the others. It's not going to, I don't want to say it has no value, but it's not going to shed light on anything new. So I don't want to say I'm against all PCAs, but maybe to that individual litigant, I think you have to concede, well, yeah, maybe they really don't see how they fit in, and an opinion would be better. I don't think Pete, and I haven't heard that. I don't come here saying that I've heard these judges don't do enough opinions. It's too many PCAs. I trust their judgment on it. I've had PCAs that have come back that I wasn't surprised it was a PCA because there was nothing there. There was really nothing there. But to the extent that you have anything unique or interesting, it is helpful to give an opinion. Sometimes stare decisis might be, to go back to that question, it might be that, you know, an opinion is an opinion, but maybe it was wrong. I mean, you do have conflicts between districts sometimes, so maybe if you're parting from a stare decisis because you think you can explain it differently, you just, you know, look, I can't explain that when I think it's different. You know, maybe the third doesn't agree with the fourth. You know, now, if the fourth internally came to change their opinion or withdraw, which isn't unique, it happens, and maybe they're just deciding, you know, unfortunately, maybe we made a mistake or thought better. After more time, we made a better decision. You can always improve on something if you go back and look at it.
Thank you.
Sounds like a long answer.
Well, I asked you 3 questions in your
So you didn't PCA the answer.
You provided guidance.
We're at the stopping point.
Okay.
Thank you so much, Judge, for coming. I'd like to give you an opportunity to make some closing remarks.
Listen, thank you for your time and consideration. I was fortunate enough, I was lucky, I had an opportunity to go visit with the governor one time before. I really appreciate the opportunity to do it again. I know there's no guarantee you get the appointment. I hope that if you find anything in that application that separates me from other people, good or bad, if you can drop me the note on, you know, what looked good or what you heard might be bad, always looking to improve, and as a judge, you can invite that, but people aren't always brave enough to do that. I think you guys at least have another level of insulation. You don't do that, because I'm asking for comments on the application. I do think the thing that I'd like to offer is I am a very diverse background. I appreciate the opportunity to be here. I appreciate what my folks did for me and my grandparents. That's why I sit in front of you today, not because I think I've done anything great. I've just run with an opportunity that to some extent probably everybody here has, and I'd like to continue to do that. I think my greatest asset, what I try to tell people, is I know that I don't know everything. I try to remember what Benjamin Franklin said, it is all about ethnography. The older I get, the more I try to remember I got to be open to other people's ideas. I may not know everything. And I'll never forget the profound impact that had on me. The guy who invented electricity could say that, you know, Mike Takac, I'll remember that, and so that's why I appreciate the opportunity. I don't think I'm any greater than anybody else. I understand I could be wrong in that, but I think that's an asset that I can do that, work with other people, and I hope that you had a diverse enough background of the people I supply, that they supply that to you, and that's why I try to reach across a cross section as opposed to just a bunch of lawyers or judges that see me every day. Although if you contact them, I'm a public official. I'll take the word of anybody who you can find would say. But again, thank you for your time, and I really appreciate your consideration, and I hope I get the opportunity to see if I can fill a vacancy here on the district court.
Thank you very
Thank
much.
you.
Judge,
Thank you all.
thank you for your service. Thank you for coming in.
Well, thank you all for your service.
It's on the right, it's the third